This is Bloomberg Law with June Grasso from Bloomberg Radio.
Last Friday, there was a stunning reversal of the announced plea deal for the alleged mastermind of 9/11 and two of his co-conspirators. It came in a letter from Secretary of Defense Lloyd Austin to the head of the U.S. Military Commission in Guantanamo, saying he was withdrawing from the 3 pretrial agreements that she'd signed just 2 days before. That deal would have seen Khalid Sheikh Mohammed and 2 others plead guilty to the murder of 2,976 people in exchange for a life sentence. Austin has said that's not the right move.
I have long believed that the families of the victims, our service members, and the American public deserve the opportunity to see military commission trials carried out in this case.
And many of the 9/11 families agree with Austin and had reacted with anger to the deal. So the death penalty is now back on the table. Joining me is Palm Beach County State Attorney Dave Arenberg. The head of the Military Commission, a retired brigadier general, signed a pretrial agreement last Wednesday with 3 of the 9/11 terrorists. There was an outcry by a lot of the family members. Then Secretary of Defense Lloyd Austin comes along and says, no, I'm not authorizing it. How unusual is it for a deal to be announced and then retracted? Right now, I can't think of another instance like it.
This case is unusual because of its magnitude. We're talking about people who are responsible for the deaths of 3,000 Americans on 9/11. And so when you make a deal like this, you have to assume that everyone has signed off on it. And I have to believe that if Secretary Austin didn't know about it, then he should have at the time. And the fact that he put the kibosh on the deal so quickly after the outcry, to me, makes me think it's a little bit about politics. There's an election coming up, and you don't want the image of all these families who have endured so much to be complaining about the United States government selling them out. And in reality, if you want to blame an administration for this, though, that's fair. But don't blame the Biden administration. You should blame the George W. Bush administration, who sanctioned torture, and that's what led us to where we are today.
Explain why this case or these cases have been languishing for so many years.
Yeah, KSM was first caught and arrested about 21 years ago. I mean, this is outrageous that it's taken this long. But when you have confessions elicited by improper means, such as torture, that's going to slow down the process. And the judge is considering whether or not to throw out the confessions. And if you lose the confessions, it makes the case that much harder. And I think the prosecutors saw that and realized that we could lose this case, and let's just get what we can and convict them and sentence them to life forever. The victims' families were not just on one side. It was a mix of opinions. Some supported the deal, some opposed it. And prosecutors just saw this, and they're not politicians, and that's why they did this so close to the election, where I got to believe the political leaders said, hey, this may be the end result that is necessary if the judge throws out the confessions. But until that happens, we're not going to enter into the settlement agreement this close to an election.
But also, they had rejected, the White House or Secretary of Defense Austin had rejected a plea deal that was talked about in last September.
Yeah, it's not clear whether or not the terms of that plea deal were accepted by the government in this version of it. We don't know whether the government accepted their demands of no solitary confinement and all these other requirements, which I find it hard to believe that you would agree to these things. If you're going to agree to make a deal with the devil, which unfortunately happens in the prosecutorial profession. I mean, it's one of the toughest things we have to do sometimes to attain a measure of justice. But if you're going to agree to that, the only thing you're going to give up is giving up the death penalty. And you're going to want to lock them up in a prison or a military prison forever. And you don't want to give them any special privileges or benefits or make concessions. You've got the ace in the hole, which is you've got evidence and you've got the power of the government dealing with enemy combatants. And so the only thing I think they would ever give up or should give up would perhaps be the death penalty, only because of the fact that if there was torture to elicit a confession, that does complicate things.
The defense attorneys called the move corrupt, the defense attorneys for the 9/11 terrorists. We had an unprecedented act by a government official to pull back what was a valid agreement. And one of the defense attorneys argued at a hearing that Austin lacked the authority under the military's manual for military commission to scrap the plea deals because the alleged terrorists had, quote, begun very important, substantive, specific performance to hold up their end of the deal. I have no idea what that possibly could be.
That means cooperation. That means giving up other people. Remember, KSM, who's the head of this, he was unrepentant. He was defiant from the beginning. Well, now here he is accepting guilt and pleading for mercy and pleading for his life. So even if this deal went through, it is a victory for the families of the 9/11 victims because they broke this guy, finally. But when I hear his lawyers saying, hey, we had a deal, we want the deal, that makes me as a prosecutor think maybe the deal wasn't so good. Maybe Secretary Austin did the right thing in stopping the deal. My only concern is if you lose the confessions because of the torture that occurred at secret CIA facilities around the world or Camp X-Ray at Gitmo, then it makes this job so much harder for prosecutors, and perhaps at that point you would have wanted the deal that had been entered into.
And the prosecutors can't be too happy that a judge in the Guantanamo case involving the bombing of the USS Cole threw out a confession that he said was the product of torture.
That's the problem. See, that's the problem. Like, Osama bin Laden deserved the death penalty. Khalid Sheikh Mohammed deserves the death penalty. But because the Bush administration had allowed torture to occur, it just makes it that much more difficult for prosecutors who cannot elicit confessions based on improper means. And not only that, it also hurt the United States' reputation around the world because it became a recruiting tool for jihadists. So for those who support the use of torture, it doesn't provide solid confessions. I mean, sadly, John McCain's not here anymore, but John McCain was opposed to torture because you elicit confessions that are not necessarily truthful, just whatever people will say at the time, and also it damages our reputation around the world, and it really is not in line with American values. You don't have to use torture to gain evidence to prosecute these people and give them the death penalty. And perhaps if the torture was not used, these people would have met the ultimate penalty already.
So this was a signed plea deal. The head of the U.S. Military Commission signed this plea agreement. Is there any legal challenge to Secretary Austin coming in and saying, no, we're not going to do it?
I mean, they can try, but Secretary of Defense does have the authority to say no to a deal. I mean, now, their best argument is that we've already started to perform our end of the deal. It's too late to turn back. But the deal had just been announced. So I don't know what kind of performance they had already done. Did he all of a sudden give up every name? And so that's going to be, I think, the decision for the court. If the court says, yeah, look what he already gave us. He gave us all this stuff that we've already acted on, but that's impossible. So I think that in the end, this is sour grapes by the defense lawyers who are just upset that the political blowback caused Secretary Austin to step in and say no. But you know what? That's our system. And they're lucky that they're not getting justice in some other countries' courts overseas where there would be no justice. They'd be their heads would be taken off immediately. So, we have a system in the United States, even in military courts, military tribunals, that's a lot more fair than what they would get elsewhere.
It wasn't disclosed where they would serve their sentence, but some of the family members were upset if their sentence would be served in Guantanamo. They wanted them to serve their sentence in a supermax prison.
There's a lot of political pushback in bringing these hardened terrorists to American soil, to our country. When there was an attempt by then Attorney General Eric Holder to have the trials in the Southern District of New York in Manhattan, politicians like Senator Schumer opposed it. They did not want these terrorists here in our community. And had that happened, had they been tried, they could have already been found guilty and been given the death penalty. So Eric Holder is saying, you see, this is the alternative is you put them in Gitmo and now you don't have true justice. It's been 21 plus years. So as far as where they serve their sentence, I think that they will serve it at Gitmo or at some military facility, not in the United States, because the precedent has been there that the politicians, the elected officials, do not want these monsters living amongst us, even in a supermax prison.
Some think that this never will go to trial because of all the problems. Do you think it can go to trial?
I think it can, but just incessant delays, and justice delayed is justice denied. And I tell you this, I know a lot of people, when they think of Gitmo, they think of Camp X-Ray, where they did torture, miserable facilities. About 7 years ago, I went to Gitmo as an observer for some of these hearings of these terrorists. And the hearing that I just randomly was watching was one where You had someone who was locked up at Gitmo whose lawyer was saying that he deserves to have his laptop with Netflix on it. We are a far cry from the days of Camp X-Ray, when now it's a question of whether or not they can have Netflix in their cells. And when I saw some of the cells, they were, I would say, even more upscale than the ones you see in some of our prisons in the United States. In the one facility I saw, there was a big arrow on the ground. And the arrow is to tell the inmates which way is Mecca, so they know where to pray during the day. And so that's how far we've come from the days where there was waterboarding at Gitmo.
So jury selection in the trial, which is expected to last 12 to 18 months, wasn't envisioned to start before 2026. And the judge in the case had been working toward deciding a series of challenges brought by defense lawyers, including whether to exclude the confessions that are key to the government's case. So I suppose the next thing we'll hear about is whether those confessions will be excluded or not. Stay with me, Dave. Coming up next on the Bloomberg Law Show, we'll take a look at where the criminal cases against former President Donald Trump stand. You're listening to Bloomberg. Former President Donald Trump was charged in 4 criminal cases, 2 in federal court and 2 in state court. One of those indictments in the New York hush money case led to the first criminal conviction of a former president. But the other cases have been stalled, one even dismissed, due to successful pretrial legal maneuvering by Trump and a controversial decision by the Supreme Court on presidential immunity. And the judge in the hush money case has set some new timetables for rulings after Trump once again asked him to recuse himself because the judge's daughter had worked for Vice President Kamala Harris. I've been talking to Palm Beach County State Attorney Dave Ehrenberg. Dave, Judge Juan Merchan pushed back the date for his ruling on presidential immunity until 2 days before Trump's scheduled sentencing. So naturally, the district attorney has urged the judge to reject Trump's argument that his felony conviction should be tossed due to presidential immunity. Tell us about the district attorney's arguments.
And it said, no, this immunity decision doesn't apply here because the actions you were convicted of took place before you were president, and to the extent that there was evidence used from aides like Hope Hicks and Madeleine Westerhout while you were president, they had nothing to do with official duties. They were a continuation of their roles before they became your employees. And in any event, even if those witnesses' testimony were admitted improperly, it was what's called harmless error. So even if you had Hope Hicks testifying and she shouldn't have because of this broad immunity ruling by the Supreme Court, it didn't make a difference in the jury's decision. You know how we know that? It's because the jury came back and asked questions before they came up with a verdict. They wanted to hear the testimony back of Michael Cohen and of David Pecker. They didn't care about Hope Hicks and what she said. Madeleine Westerhout just gave some basic technical stuff like ministerial information. Now, the sentence will happen on the day it's supposed to. I think it's September 18th. And then it will be appealed by Trump, and there will be delays. He will not serve a day before the election. And if he does become president again, he'll find a way, I think, to avoid serving any time at all.
Let's talk about the D.C. election interference case, because it was returned to the trial judge, Tanya Chutkin, last Friday, August 2nd. That was 1 month after the Supreme Court issued that game-changing ruling on presidential immunity. And then on August 3rd, the next day, which was a Saturday, she issued her first ruling refusing Trump's efforts to dismiss the case based on accusations that Joe Biden pushed prosecutors to target him. Do you think the judge has been working during this delay due to the Supreme Court?
Yeah, Judge Chutkin is a really good judge, and she wanted this case to go, and she was told to stand back and stand by the U.S. Supreme Court. And once she was allowed to get the case again, she's moving ahead. But it doesn't mean that while there was a stay, she wasn't reading up on stuff and just preparing. She even said previously she would cancel her summer international vacation if that's what it took to try the case. Well, she's not going to be able to try the case before the election, but she could have an evidentiary hearing to determine whether Trump's actions fall under official duties or unofficial duties. And that could embarrass Trump because that would be open to the public and they would see some of the stuff he did before, during, and after January 6th. So it's going to be up to her. There's a scheduling order tomorrow that's coming out, a joint scheduling order between Trump's lawyers and Jack Smith's team. And I think that will give us some indication of where this is headed. I do think there will be action in this case before the election. Whether there's a full evidentiary hearing, like a mini trial, as some of us wanted, not sure yet. We'll know a lot more tomorrow.
She's also scheduled an August 16th status conference.
Yeah, so she's moving forward. See, Trump would just like to throw this under the rug, say postpone this till after the election or postpone it till half past never. But she's moving ahead. And she had to be a little perturbed because she was all set to go with this case and then saw how the Supreme Court, not only did they Bigfoot her and step in and put the kibosh on it, but they had a chance back in December to intervene, and they refused to do so. So they let the D.C. Circuit Court of Appeals rule, which they did a very thorough job in ruling, and then they came back and said, yeah, now we're going to undo it. And I got to believe, like the rest of us, she's probably thinking, why didn't you just tell us this in advance? Because through their actions, they do look like they're putting their thumb on the scale for Donald Trump. And that's why people have such a dim view of the Supreme Court these days. They look like a political institution. They're not supposed to. They're supposed to be above politics. Chief Justice Roberts wants us to buy into the Supreme Court as an apolitical institution. But he's part of the problem. He's the one who wrote the opinion in the immunity case. He's the one who offered such broad immunity that even Justice Amy Coney Barrett, a Trump appointee, could not go along with part of it. So that's why I think, he's hoist by his own petard. This is a problem of his own making.
We should mention that if the Chief Justice is in the majority in a case, he decides who's going to write the opinion. And this term, he wrote the majority opinion in two very important cases, the presidential immunity case and the decision to throw away the Chevron doctrine.
He went farther than any of us thought he would go because not only did he offer this broad immunity and a presumption of immunity for any semi-outer band of an official act, but he also refused to even say what is an unofficial act according to the indictment. He refused to say, like, hey, maybe the fake elector scheme is an unofficial act. No, he wouldn't say that. Maybe speaking at the ellipse and, antagonizing people, is that an unofficial act? No. Calling Brad Raffensperger saying you're going to, find me 11,780 votes, is that an unofficial act? No, maybe not. So he could have put forward at Wheels of Motion at least a smaller trial for Jack Smith, but he refused to do even that. And that's where Justice Amy Coney Barrett said, hey, there were some easy parts of this indictment you could have allowed to go forward, and you didn't. And then he said you can't even inquire into the executive branch to ask questions and interview witnesses and gain evidence, even if it relates to unofficial acts, because it could hurt the powers of the presidency. That's the worst part of the ruling. So he has made it very hard for prosecutors, and I think the ruling in itself is so confusing that at some point they're going to have to revisit it.
Well, just like they're revisiting the decision taking away the constitutional right to abortion, they're going to be revisiting the decision taking away Chevron. A lot more work for themselves. So let's talk about the Florida case, which is completely off track. So Jack Smith is appealing. Do we know when he's going to file his papers?
Well, he's going to the 11th Circuit. He could have just said, all right, I'm not going to appeal. Let's refile the case through the U.S. Attorney's Office, not through Jack Smith. And then it would go faster and maybe even get a better, Freudian slip, a different judge.
Better.
I won't say that, but yes,
Smith.
but it can't be worse for Jack Smith. Yeah. I mean, Judge Cannon is inexperienced. She has been delaying so many hearings and then has come up with such radical rulings that many observers like me are shaking their heads.
As you mentioned, he could have refiled this. Wouldn't that have been an easier and quicker way to deal with this?
Yes, but I think the Department of Justice did not want such an errant ruling to sit there. They wanted to appeal it to get that overturned. They believe, as I do, as probably you and most other people do, that Judge Cannon's ruling was wrongfully decided. It goes against all the precedent out there. Every other case is ruled the other way. So now you have a case that is in opposition to precedent. So what do? You try to overturn it. The problem is, even though I do think he's going to get it overturned by the 11th Circuit, what happens when the Supreme Court picks it up? We thought that the immunity decision was a no-brainer. Are they going to come up with some new radical opinion that puts a hold on the special counsel? And even if they just take it up and rule for Jack Smith, look at all those delays you have. I say just go ahead and let that opinion sit as an outlier, ignore it, and then have the U.S. Attorney's Office file it again in the Southern District of Florida and move forward there. Now, I know another objection is that, well, that'll look more political. That's why there needs to be a special counsel. Well, come on. You can't persuade the unpersuadable. You're always going to look political whether you do or you don't. Just do what's right for the cause of justice.
So it goes to the 11th Circuit, which is predominantly Republican-appointed judges.
Majority. It's conservative.
It's conservative. And so in the first instance, it'll go to a panel, 3-judge panel. Does it matter who's on that panel, do you think, in this case?
Well, if you look at the panel that had the last appeal of a Judge Cannon order, the one involving the special master, that panel had 3 judges appointed by Republicans. Judge Pryor, who's the chief judge there, who was on the short list for the U.S. Supreme Court for President Bush, he was one of the judges, and the other 2 judges were appointed by Donald Trump himself, and all 3 judges ruled against Judge Cannon and humiliated her, repudiated her in no uncertain terms. So I don't think it matters who's on the panel. I think they're going to repudiate her again, but they will not take her off this case for this. I think the reason why Judge Cannon felt empowered to do what she did, to do something so radical, is because Justice Clarence Thomas, in the immunity decision, he did a concurring opinion that set forth a roadmap for Judge Cannon. Even though this wasn't even an issue in front of Justice Thomas, he gave her some maps of how to undo the special counsel, like a wink and a nod to her. And she took the bait. She ran with it. And that's why I don't think she can be taken off the case by the 11th Circuit when you're following the ruling, even though it's just a concurring ruling that no one else signed off on, of Justice Clarence Thomas.
But what about all her decisions slowing down the case?
Well, you have a lot of discretion as a judge on your scheduling. So her decisions to delay and ponder things, not going to get her bounced from the case. What will get her bounced is when she makes a radical ruling that goes against precedent and shows bias. And this, I think, would have gotten her taken off the case, but for Justice Clarence Thomas's concurring opinion, which no one else signed off on. So that makes me believe perhaps if this goes back to the U.S. Supreme Court, which I think it inevitably will, that Jack Smith will win. It's just more delays.
Well, we thought he would win on presidential immunity, too. So I think like all bets are off at this point as to what the Supreme Court will do. What about bringing the case in New Jersey or in D.C.?
Yeah, it's tougher. Bedminster, New Jersey, where he waved around that document, you could try to do it based on that one document, but the documents are all at Mar-a-Lago that he took from the White House. And so it's really not D.C. or Bedminster. You could try to do a little bit, maybe that one document, Bedminster, that we apparently know that he had, that he was waving around. That's unlawful retention. Perhaps that's dissemination. But as far as where the case really needs to be, the obstruction, the violation of the Espionage Act, that allegedly occurred in South Florida, in Mar-a-Lago, once he was a former president. And you don't want to get into a game of venue wars where it's going to go up to appellate courts and then you get repudiated for trying to play the game of forum shopping. It belongs in South Florida. Do it there. He just got unlucky in getting Judge Cannon, which is why he should, I think, refile it and see if the chief judge will assign a different judge.
But isn't it a random assignment?
It is, and since Judge Cannon has this case, it's likely that she would get a refiled case again. But the chief judge down there, remember, said that, hey, I think you should not be on this case. Remember? And yet she said, no, I can handle it. So I think, since the chief judge is the one who has some say in here, she may direct this case as a different judge if it's refiled down there properly from the U.S. Attorney's Office.
That's unlikely, though. All indications are that Jack Smith is going to file an appeal with the 11th Circuit. Thanks so much for coming on the show, Dave. That's Palm Beach County State Attorney Dave Aronberg. Coming up next, half of the NBA teams are sued for copyright infringement. This is Bloomberg. You know those catchy TikTok videos your favorite NBA team puts out? Well, nearly half the teams in the NBA are being sued for using copyrighted music by artists like Pitbull, Dua Lipa, Miley Cyrus, and Cardi B in promotional videos on TikTok, Facebook, Instagram, YouTube, and X, formerly Twitter. The New York Knicks, the Philadelphia 76ers, the Atlanta Hawks, and the Minnesota Timberwolves are among the teams being sued for syncing songs to video without permission. And the complaint alleges that the teams knew they were willfully infringing on the intellectual property rights. Joining me is intellectual property litigator Terrence Voss, a partner at Catton Muchin Rosenman. There are three different kinds of copyright infringement alleged: direct copyright infringement, contributory copyright infringement, and vicarious copyright infringement. What's the difference there?
So the difference is essentially in who did what. Each of these 14 complaints is against a different NBA basketball team. But in addition to naming the basketball team, it names multiple John or Jane Does who have yet to be discovered. And that's what really counts 2 and 3 of each. So count 1 is for direct copyright infringement, probably directed against the team. I'm saying, hey, look, you used our songs without authorization, without taking a license. Therefore, you've committed direct copyright infringement. There probably are individuals who affected that. The person who actually loaded the video onto the social media platform, or if there was a third-party business that was responsible for the social media account for a team, they might be liable for contributing to the copyright infringement committed by the team. And so those are really more sort of belt and suspender causes of action that are designed to just make sure that somebody doesn't slip out from under the ambit of the lawsuit by saying, well, I didn't directly do it. I simply helped them to do it. So in a real sense, the cause of action here is for copyright infringement, and I think you can largely ignore the difference between contributory and direct infringement.
The complaint says defendants are acutely aware of the protections that the copyright laws afford, so they utilize the full extent of legal protections for their own intellectual property while willingly infringing on the intellectual property rights of the plaintiffs. So, 14 teams, they must have known. Didn't they get legal advice that this was not allowed without a license?
Well, certainly each of these teams owns copyrights and trademarks in types of intellectual property. Fundamentally, the NBA is an entertainment business, right? Entertaining all of us through competitive sports. And as with any entertainment business, they have to have copyrights on their broadcast, trademarks on their logos, on the team names, etc. So they are aware of intellectual property laws. There's no question about that. And that paragraph in the complaint is sort of a gotcha. You guys knew about the copyright laws, but you went ahead and violated them anyway. And the bigger question that you pose is, how did this happen? Each of these NBA teams have in-house legal staff. The league has a fairly large in-house legal staff that can be accessed by the teams as necessary. Most of the trademark registration process goes through the league, not through the individual teams. And so the question is a very good one that you asked, June. How could this have happened? And the simple answer is that, as with many corporations, the mere fact that you're big and that you have knowledge of the intellectual property laws doesn't mean that you have a large enough legal staff or a legal staff that is experienced in intellectual property to be able to deal with every problem that comes up. The biggest problems that NBA teams face are labor and employment issues. Mm-hmm. So they obviously have people who are very familiar with employment issues and with the collective bargaining agreement. They also have basic contract problems, contracts with the venue that they play in, contracts with sponsors. And so they obviously have people on their legal staff who are very familiar with contracts. That doesn't mean that they're going to have a copyright specialist, because that doesn't come up as often. And they probably, when they have a problem, refer it to outside counsel in that field. And so the simple answer is, yeah, they're a big corporation, but when it comes to social media platforms, they're often no more cognizant of what the rules are than any layperson like your kid or my kid.
As far as possible defenses, might they claim fair use? It was a pretty quick sampling of the music?
I'm sure that they will claim that, and it would be a colorable defense, let's just say. I'm not sure that it would succeed in the long run, but it would certainly be a colorable defense. Here's the problem that they face. Each of these social media sites has a license with the major music publishing houses and recording studios, and they have available to their users hundreds of thousands of pieces of music. The problem is that license is limited to non-commercial use. And this is where companies make mistakes all the time on social media platforms. And these lawsuits are truly a cautionary tale for every business that should wake up and pay attention here. When a business goes on a social media platform, it's simply assumed that you're doing that for commercial purposes. You're a business. What other purpose could there be other than for a commercial purpose? And therefore, that license that individual users, teenagers, for example, can take advantage of cannot be taken advantage of by a business because it expressly excludes commercial use on these websites, whether it be TikTok or Instagram And that's the problem here, is that these NBA teams did not seem to be cognizant of that limitation on the general available license and simply assumed that they could do this, and nobody really thought twice.
And I assumed isn't a defense.
I assumed is not a defense. Like that famous Steve Martin bit where I was, sorry, Your Honor, I didn't know that armed robbery was against the law. You just can't, that doesn't work in a court of law. Fair use is a legitimate defense, but in light of the fact that they were trying to take advantage of a license to the site for music and simply didn't comply in the right way, it makes it really hard to then succeed with the fair use defense, in my opinion.
Music owners have been cracking down on these social media uses, and all three major labels sued drink maker Bang Energy for using hundreds of copyrighted songs in TikTok videos. A judge did rule in that case. He said it doesn't really matter what Bang thought, which goes to the Steve Martin clip. Have these cases gone to judges or appellate courts yet?
So there's a large number of these that have been percolating over the last year. The Beastie Boys sued Chili's, the restaurant chain, for using their song Sabotage in social media clips. Sony sued Marriott just this last May for using some of its songs. Sony has a very large music catalog, and for Marriott apparently used some of those in its social media platform campaigns. So you're seeing this happen all the time. It's part of a broader trend within the music business. I mean, the music industry and performers in general believe that they're being undercompensated. And so they have become very aggressive on the litigation front. There have been a number of lawsuits against streaming platforms. Most recently, Verizon got sued, alleging that they are willfully allowing this to happen, that people share songs, notwithstanding getting copious numbers of copyright takedown notices from the music companies. And so this is just part of a larger trend of pushing back by music companies, recording studios, performers to try to capture more monetary compensation for their work.
Because to me, this seems like an open and shut case.
Well, look, if I got hired to represent one of the teams, I'd be calling and trying to answer real quick what they want. You know, litigating a lawsuit like this can only be embarrassing at best, and at worst can really be a black eye for a team, particularly since the music alleged to be used here is by some of the most popular performers on the contemporary music scene. The allegations are that the songs used came from Pitbull, Doja Cat, Dua Lipa, Miley Cyrus, Jay-Z, Cardi B, just to name a few. I mean, these are really popular performers, and their fans tend to resent it when their music is being used improperly like this. And so this can only be a black eye for these NBA teams. There's that old saying, you know, the first rule of holes, H-O-L-E-S, is when you're in a hole, stop digging. And so my view is, you know, I'd invoke mea culpa, maxima culpa, and do my 5 Hail Marys and penance and move on. You know, just what is it that you want to make this go away, and do it. And we'll promise never to do it again. And then I put in place some sort of training for the people who are actually doing my social media platform so that this never happens again. Now, part of the problem here is that sometimes corporations farm that work out to third parties. I mean, there are lots of companies who, for a price, will do your social media postings for you. That's what most celebrities have. You don't see people like Kevin Durant sitting down and doing his own posting on TikTok. What you see is wealthy people and big corporations pushing that out, outsourcing it to a third party who will do it for them, and that's a different problem. To the extent the NBA teams are doing that, not doing it in-house, they've got to crack down on that and make sure that their third-party vendors who are providing these services are doing it in a lawful way.
Maybe the Knicks thought that since Jay-Z is such a fan and sits courtside all the time, he wouldn't mind if they used his song.
That could well be the case. I don't know. I suspect, honestly, we can laugh about this, and it is comical in some ways, but I suspect that none of these teams realized what was going on. None of these teams would have willfully set out to break the copyright laws because they have their own copyrights and don't want them infringed. This is a mistake that the teams made, and it's what we would call in the business innocent infringement, and they should just do their penance, figure out what it needs to make this go away, and make sure it doesn't happen again.
It'll probably take more than a few Hail Marys, though. Thanks so much, Terry. That's intellectual property litigator Terrence Ross, a partner at Catton Muchin Rosenman. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.